So now there are too much slides to hand in a safe way. So I will present the intellectual property part rapidly. So there are many things about IP, and you can protect it in different way. If you look at The Economist this week, you have a paper about the secrecy. So I invite you to read it. So if you patent a technology, you will disclose it to everyone. Okay? So you will get a protection for 20 years, but you will disclose it. If you are not able to check that there is some infringement to your patent, maybe it's more intelligent to keep the secret on different aspects. Patent filing is a way, a privileged way to protect the IP, and there is no dilemma, in fact, between publication and patenting. The only rule is you have to apply for the patent before publish a scientific paper, and if you do it before, there is no problem for the intellectual property rights you can get from the patent procedure. So it's sometimes believed that you cannot publish if you patent. It is not true. You cannot patent if you have published before. So there are other rights like the copyright that we often use on software and databases, the trademarks, and the authorship, which is a de facto right. It means that you do not have to apply for to get it. So I will focus on IP and patent. So you can find different definition on the websites, for example, of the EPO, the European Patent Office, of the WIPO, the World Intellectual Property Organization. So I invite you to go to this website and read the tutorials, for example. But here you have got a short introduction. So a patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. In order to be patentable, the invention must fulfill at least 3 criteria. The protection lasts for 20 years generally. It can be prolonged for 5 years. And the patent is a legal title which excludes order of exploiting your technology or your product. So what are the 3 main criteria? Because there are other formal criteria. So the first one is novelty. So when you want to apply for a patent, you have to look at the patent databases and define a clear position of your solution compared to the other patents and show that you have an element of novelty. Okay? It must be new. So it must be new. That is quite an objective criteria because you compare it to the prior art, and the prior art begins the day before you apply for your patent. Okay? The second criteria is that you have to have an inventive step. Okay? So for somebody which is the main of the art, okay, it's a concept, which knows everything about the domain, it is not obvious to find a solution to the problem with all the prior art he has. I can give you some example. If you are a civil engineer and you have to build a bridge, okay, and there is no bridge at the place, you will build something new, okay? But it's not inventive because you will use all what you have learned, all what you've been taught in order to construct that bridge. If there is a specific problem and you invent a new way of constructing or building this bridge, then you have an inventive step. A difference between a discovery and an invention can be done also with this inventive step. For example, when you discover the X-ray, okay, it's not patentable as such. Röntgen could not have applied for X-ray as such. But if you use the X-ray in order to do radiography, okay, it becomes an artifact and you have an invention. So this is also the third criteria, that you do have to have practical application of the invention. Okay? So novelty, inventiveness, and practical application or industrial application are the three main criteria to apply for the patent. There are some fields that are excluded from patenting, and the right differs in Europe and the United States, as you know. In many countries, scientific theories, mathematical methods, plants or animal varieties, discoveries of natural substance are not patentable, so they are excluded from the patent scope. So I invite you to go to the tutorial of the European Patent Office, and this schema is a simplified procedure because there are many procedures to apply for the patent, but it takes time to be granted. On average, 5 to 7 years. There are acceleration procedures that you can ask for, but nobody does that. 99% of the patents do not enter an accelerated procedure. Why? Because it costs much to get the patent at the end, and in parallel, it is no use to apply for a patent if you do not have a clear commercial strategy to valorize it. Okay? So, when you apply for a patent, you are potentially protected from the day you have applied for, and the right will be executable from the granting with a retroactive execution of your rights. So you apply for the patent at the priority date, it's time 0, and in general you will apply for local patent. Then after 1 year you have the possibility to add something to your patent. Okay? So, and in general, we will enter a Pct phase, that is the Patent Cooperation Treaty. This application allows you to maintain the possibility to apply in every country in the world, because at the end, the patent is a national right. Okay? As it is not possible to apply in each country on the same date, you have 1 year to apply, but there are some international treaties like the Pct that can help you to maintain the possibility to enter later into the national phases. So, in order to have the lowest cost, I suggest you to think about this procedure. So, you apply for a patent in Poland, for example. Then 12 months later, you apply for the Pct phase. During this year, you have the possibility to add specification from, for example, your proof of concept phase. And after 18 months, the patent application will be disclosed. So for 18 months, nobody knows that you have applied for the patent. Okay? So when you evaluate the prior art, you must know that you do not have access to all the patents that have been filled in during the last 18 months. Okay, so it's important to go to the patent databases regularly if you have choices to make. After 30 months, you have the end of the Pct phase and you enter the national phase. And then you have to have a clear view of the commercialization that you want to have, because you will translate the patent in each language you need, and it costs really much money at this phase. Okay, so 2.5 years after the first application. In general, the granting occurs after 5 years, and during all the process, you have examiner that say, okay, it's not new, because that patent say the same things, or this aspect is not new, or this aspect is not inventive, and you can answer all the objection that you've been sent by the examiners. Okay, so all these aspects cost money too, and it is important so to have, I'd say, a good evaluation and a continuous evaluation of the economical potential of your patent through the patent procedure. Okay? Because when you make the choices at the different steps, you must know better and better your market and what is the value of the technology and the product and the patent. Okay? It's not an easy way to evaluate the value of a new technology. There are many techniques. I will not have time to present it today, but what is important is to understand that during the procedure you have to look at the market and the potential of the market. So this is a real patent granted from the United States. And these are, I will give you the slides, these are different websites where you can find the patent literature. So the World Intellectual Property Organization, the European Patent Office with their database of Patent Scope and ESPASnet, and so. So here is an exercise, so you will have the slide, you can do the exercise. Just try to find a patent from someone, so you know the inventors, you know the title. Okay.
I've got a question, because I heard that it is impossible to make a patent on algorithms in Europe. Is it true?
Okay, we cannot. Okay, the right differs in Europe and in the United States. So in Europe, you cannot apply for a patent for a code, a software code as such. Okay. So in fact, the title here is misleading, and it's often the case that the titles are misleading, because there is sometimes you just do not want that others see what are your real protection. But okay, you cannot apply for an algorithm as such, but you can apply for software code that is embedded. Okay, and here it is in fact a whole process that is described in medicine to better define the response to some treatment in breast cancer. So it was based on an algorithm, but the patent is related to the whole process and method. So how you can get the tissue, how to analyze the tissue, how you get the data, and then you have the formula, but it's not the formula that is protected as such. Okay? So you're right.
So it's like with this X-ray, you don't patent X-ray, but you can patent the radiography process. So the X-ray is the X-ray, everybody can use it, but he cannot use it for the radiography because you protected it.
Okay.
So here you use.
So you can somehow convey those words.
Excuse me?
Right? So you can change the word algorithm to method and.
No, it's depend. There are 50 pages, so.
Yeah, I'm aware of
Okay,
it.
this is the title. Okay. So I can explain the technology after, but you're right. The algorithm as such cannot be applied for, but there are different parts in the patent. So you can see here what is important. So you have the application date. You have the international publication date. You have the international filing date. So you, okay, have you ever read a patent? Yeah? So the different dates depends on the procedure I showed you before. Okay? So the application date is time 0. The international filing date is 12 months later. The publication date is 18 months later, and so on. Here you have the applicant. So there is a difference between the applicant, who is the owner, and the inventors. Okay? In this case, the applicant is the Université Libre de Bruxelles, okay, Brussels University, and the inventors are professors in the university. Okay? I did not tell you that in general, in the rules of the university owns the IP, but there is some incentive for the researcher, and you have to define what is the incentive. Typically, it's 1/3 of the royalties. Huh? So there is an abstract. So the present invention is related to methods and systems determination in tumor sample by measuring gene expression and applying a gene expression grade. So it's to evaluate what is the response to some treatment. Okay? Then you have a description of the invention. In the description of the invention, you have a part that is the prior art. So you have to describe what does exist before. So like in a scientific paper. Then you have the description of your invention, then you have the claims. And the claims is exactly what you ask for protection. And you have different claims. It's really important to think about what are the claims that you will ask for. So in general, you will have a discussion with a patent attorney. Okay, you cannot apply for a patent yourself. You have to ask an official patent attorney to apply for it for you. Okay, so in the claim, in general, you have the first claim that must be the most general possible, and then you have depending claims, and you are more and more and more specific. In order to have the broader protection you can have, and then finally to protect exactly what you have. So if you have some minutes, so this patent was about histological grade in breast cancer. Before this patent, people, women that suffers breast cancer were analyzed by histopathologists. So we take some tumor cells and we analyze with a microscope. And with the microscope, an expert says, okay, that is grade 1, or that is grade 2, or that is grade 3. Grade 1 means that there is a low mortality rate. Grade 3 means that there is a high mortality rate. And grade 2 means that we don't know. Okay? And if you have asked different experts to analyze the tissue with the microscope, in fact, you have different evaluation. Okay? So it was not a quantitative analysis, but a qualitative analysis. With the new technology, I will not enter into the details, but you can see that it comes from nature, so with high impact factor. So there is the relation between good patents and good publication. Also, you can see, I will not enter into the details, that with quantitative analysis, you can differentiate grade 2 patient between the low risk and high risk. In fact, the grade 2 does not exist. So, okay, it's engineers and data miners that have shown that analyzing the data, the quantitative data on omics. So this is the discovery, how to transform that into a product. Have you an idea? Have you understood the basics here? Okay. Before we'll look at the tissue with a microscope and an expert says, okay, it's grade 1, it's grade 3, or it's grade 2. Now we can just pick up the tissue and say it's grade 1 or it's grade 3 because it's another technique. But this is a scientific discovery, which is grade 2 does not exist. How to transform that into a product or a service. So this is another publication showing that, but we do not have time. This slide, I put it here because, and you have to pay attention to that, because the date you find here, 13 May 2005, was exactly the date of the application of the patent. Okay? So, so it was exactly the date. So the prior art begins one day before the application date. Okay? But pay attention to that, because when you go to a conference, you send the abstract, and often it is the case that on the website you have the abstract before you disclose it, before you present it. So it's often important to ask for an embargo, not putting the abstract on the website, because if the patent is not applied for, you would lose the rights if it was put on the website. Am I clear? It is really important, huh?
That's the question.
Yeah.
By sending the abstract, right, to
Yeah.
the conference,
Yeah, this is confidential. Yeah.
Somebody will read it, but it's still not, there's not disclosed to the public.
No. So disclosing is defined in the patent rights literature as it may be accessible to the public.
I see.
Accessible to the public. It does not mean that somebody has read it. Okay? If the potentiality exists one day that people could access to this information, like you put your PhD thesis in the library and nobody has looked at it, but it was in the library, you lose the right if you apply for the patent after having put it in the library. Okay? So when you send an abstract to the conference, it is confidential, because there is a confidential agreement during the procedure. But once accepted, take care and ask for an embargo if you intend to apply for a patent. Because otherwise, you will lose your own rights on the patent. Because it's not new. It's not new because it was accessible to the public before you have applied for the patent. This is the European right. In the US, if you are the inventor and the discloser, you have 1 year to apply for the patent. In Europe, if you talk about your invention in details before patenting it, you take a big risk.
Okay.
So you can enter into negotiation or evaluate collaboration, but you have to sign a non-disclosure agreement, really precise non-disclosure agreement. But I rather prefer applying first before discussing.
Somebody steals my research. He stole my laptop and he posted it on the blog.
Okay. In the US, you can prove because you have notes, and so you can prove that you were the first inventor. So you can get your rights back and ask for the patent. In Europe, you lose the right, but you can go into court and with him saying, okay, he stole my idea, I can prove it. Okay, but be precise when you talk. Sign a non-disclosure agreement. Be precise on what are the data you give to the other, and not a general template non-disclosure agreement. You will not get any clue for the going into court. But okay, what can I say? Yeah, you will not apply for the patent, but you can go into court and say, okay, he stole my idea.
And maybe after 20 years.
I can also go to my mother and cry.
Yeah.
It's stolen.
So be careful. Yeah. So additional exercises. Okay, if you have time. Some business basic.
If you allow one question concerning algorithms,
Yeah.
What do you think about the idea to patent algorithms as a specialized computing unit in hardware realized, but exactly repeating all operations which you foresee in your algorithm? Each in our computer will repeat during, if you apply this algorithm in the computer, some units will process in just in the same way, like in your hardware unit.
Yeah.
And I patent unit, and I claim that this unit will repeat whole operations which will be realized in another computer, which will use this algorithm. Is it possible to patent hardware repeating the calculation of algorithm and to say this is mine?
You should have two aspects. So, okay, you can do an electronic circuit that develop exactly an algorithm. Okay, so you have to have the software embedded or the electronic circuit, and you have to have a physical effect. Okay, so you have to move something in the world, I would say. Okay, so the machine must have a physical effect.
Are electrons enough? If I
No, not at the electrons level. You have to actuate on the world. Okay, so it's quite easy to find ways to patent softwares if you are embedded and if you have a physical effect. Okay, so it's not enough to have just the process of calculating in an electronic circuit. You have to find that you will use it in certain ways to do something. And not only computation and calculation. Is it clear?
So if a control system, for example, of a robotics,
Yeah.
of a robot system is embedded, it can be patented, right? It's not like
Yes,
a patent.
because the
But
robot
it must
do
be
something. So
embedded, well, in terms of specialized hardware, or it can be, well, a control system, a software control system.
So you cannot patent the software as such. You have to have the software embedded in general, and that it does something on the real world. That are the two aspects. So, for example, if you come with a car to a barrier and the barrier goes up, okay, you have a physical effect. Okay, the software is simple, but you've defined a system that can decide whether the barrier goes up or not if a car comes, and you will protect that ID. And it's a more effective protection than only the code, because on the code you can code that in many different ways. Huh? Okay. So, just to say that the patents are also useful in the business analysis and market analysis you can do. So, for example, for each patent you have an international patent classification. So you can compare the patent with the category to which it belongs. For example, how many patents have been applied for in a specific field? Okay? Who applied for these patents? Where do they ask for protection? With all these questions that you can have the information from the patent database, you can see if there is a trend, a growth on patenting in this field or specific field, because the IPC classification can be very specific. Huh? It's hierarchical. Who applied for this patent, you will get an idea of your competitors. Huh? Who do they ask for protection, you will get an idea of the market. Huh? Where is the product sold? For example, here on the technology I showed you before, you see a clear trend here. Sorry, but I need